December 1999. An inventor by the name of Ross Eugene Long files a patent for a seemingly innocuous product, the chew toy. Specifically, an apparatus for use as a toy by an animal, for example a dog, to either fetch, carry, or chew, that includes a main section with at least one protrusion extending that resembles a branch in appearance. In March 2002, the patent was approved, and on paper, Ross became the sole proprietor of the designs for a stick. My name is Nathan, and for this video, I thought I would do something a little different. I've been studying IP law this semester at uni, and I've learned a great deal recently about how the patenting process works. Since we live in a world of constant creation and exploration of new ideas, I thought it might be interesting to go into the pros and cons of the patent system, and explore when it is that you might actually want to apply for one. Please note that I am Australian and will be talking about Australian law. However, fret not, for thanks to international treaties like the Patent Cooperation Treaty, there is a significant deal of resemblance between the legal systems across the world. So what is a patent? According to ipaustralia.gov.au, a patent is a right that is granted for any device, substance, method, or process that is new, inventive, and useful. It is a legally enforceable right to commercially exploit the invention for the life of the patent. You can also obtain patent protection overseas. What this means is that patents aren't protection for ideas. You need to have an execution of your design with schematics for its recreation and operation. Furthermore, the product needs to be new, so make sure you keep it a secret until you apply for patent protection. If you demonstrate, sell, or discuss your invention in public before you apply, you may lose the opportunity to patent it. This doesn't preclude you from talking details with business partners or employees, but consider using written NDAs when dealing with such matters. But if the patent needs to be new, how did Ross manage to get a patent for his stick? The answer lies in the priority date of the patent. This is an important concept for potential patentees and is the date you first file the application for your invention. When others want to file a patent, they have to ensure there were no other priority dates set for the same type of product. In Ross's case, this means his application was the first of its kind to patent the chew toy. Now I hear you. What's the point of patenting an idea anyone uses anyway? Was it worth it for Ross to protect his product? Well, while there was nothing preventing him from obtaining the patent originally, it's futile relying on the protection of a patent unless you have a plan for commercialization and can defend it against infringement. There are two primary factors to keep in mind when deciding whether you should patent. First, the possibility of commercial returns must outweigh the time, effort, and money required to acquire and maintain a patent. This should go without saying, but the patent process can get bloated with processing fees and application delays very quickly. It is much easier to get the patent than it is to rely on it, so you should thoroughly research whether you can spare the resources required if the time ever came that you had to use the patent's protection. Second, in the case that you can protect the product, you must be sure that you would properly benefit from the monopoly, i.e. it would be worse than the cost of reliance if others were to use your idea without credit. Keep in mind that you can always keep a trade secret instead. The patent system is not only there to protect you, but also to enrich others with the understanding of your product. If you're not looking for that, you shouldn't apply for a patent. So to recap, Ross Eugene Long successfully filed a patent for his chew toy design, as it was the first of its kind to be registered in the system. However, his ability to rely on its legal powers of monopoly are quite slim. In Ross's case, his product was neither publicly undisclosed or new to the market to warrant any valid form of protection if he so relied upon it. On the other hand, if your product is new, novel, and publicly undisclosed, you may still be too early in development in order to offset the costs of legal protection with the product's commercial return. It should go without saying, but patenting and commercializing an invention costs a lot of money and time, and it requires a range of skills we don't all have. While in this video I tried my best to cover the broad strokes of patent law, the fine details of the process are highly specific to your case, and if this is something you are interested in pursuing, I strongly recommend you seek advice from a patent attorney. You wouldn't take out a loan without first seeking professional guidance, and yet obtaining a patent is far more complex. If you get it wrong from the outset, it can be impossible to correct an error, resulting in lost opportunity with your invention. Thanks for watching. This video was not brought to you by Squarespace. I have just always wanted to say that on the internet. If you kind of like this stuff, do me a favor and let me know, because I'm completely winging it and have no idea what I'm doing. If you're confused how you got this far down the rabbit hole of YouTube, then may I lead you to further enlightenment with some of our indie game development reels. Thanks for watching, and have a good one.